Afternoon and welcome. I'm Ellie Kemeter with Foley and Lardner, and I'm pleased to welcome you to today's Environmental Law Update web conference. In this program, we address Clearing the Waters, a discussion of the new waters of the U.S. rule. I'd like to take a moment to introduce our program speakers for today. First, we have Sarah Slack. Sarah is a senior counsel with Foley and Lardner, dividing her time between remediation and redevelopment work, environmental compliance counseling, transactions, and environmental litigation. She has extensive experience on the cutting edge of Clean Air Act, Clean Water Act, Superfund, and Resource Conservation and Recovery Act enforcement. Second, we have Louis Thorson. Louis is an associate with Foley and Lardner, where he assists clients with various regulatory compliance matters under federal and state environmental laws and regulations, including the Comprehensive Environmental Response, Compensation and Liability Act, the Resource Conservation and Recovery Act, the Clean Air Act, the Clean Water Act, the Toxic Substances Control Act, the Safe Drinking Act, the National Environmental Policy Act, and various state equivalents. Lastly, we have Dick Stoll. Dick is a partner with Foley and Lardner and concentrates his practice on federal, administrative, and environmental law matters. He has been practicing environmental and administrative law since the 1970s, where he joined the EPA Office of General Counsel. He was involved in the development of regulations under the Clean Air and Water Acts and RCRA, and with the interpretation and application of those rules. Before I turn the presentation over to our speakers, I'd like to go over a few housekeeping items. Today's program will last approximately 1 hour, followed by a short question and answer session. We encourage you to submit written questions during the program. Please type your questions into the Q&A widget open on the left-hand side of your screen. We will respond to written questions at the end of the program, time permitting. The webcast console you are looking at can be completely customized. You can resize or move any of the windows that you have open, including maximizing the PowerPoint presentation on your screen. If you experience technical difficulties during the presentation, please visit the webcast help guide by clicking the help widget below the presentation window, which is designated with a question mark icon. The PowerPoint presentation will be available on our website at foley.com in the next few days, or you can get a copy of the slides in the resource list widget. As a reminder, today's program is being recorded and will also be available on Foley's website in the next few days. Foley has if you do not supply your HRCI credit or CLE information upon registration, please send it to Ellie Kemeter at ekemmeter@foley.com. To be eligible for CLE, you will need to log into the On24 session and answer a polling question during the program. As a final note, those seeking Kansas, New York, and New Jersey CLE credit are required to complete the attorney affirmation form in addition to the polling question that will appear during the program. A 5-digit code will be announced during the presentation. Please email the form to Ellie Kemeter at ekemmeter@foley.com immediately following the program. And now I would like to turn the presentation over to Sarah Slack.
Thanks, Ellie. Good morning and good afternoon, everyone. My name is Sarah Slack, and as you know, today we're here to talk about the new waters of the U.S. rule. So this is just a quick outline to show you what we're going to talk about today. We're going to start by having a brief overview about what navigable waters are, what the applicable federal law is, and what's required for those types of waters. We're going to move into a discussion of the case and policy history, and specifically talk about some of the relevant Supreme Court decisions, as well as some of the agency guidance and interpretations. And that's particularly relevant given the history of the back and forth of this definition, and to kind of set the stage and the context for where we are today with the new rule. Next, I'll turn it over to my colleague Louis Thorson, and Louis is going to focus on the new rule itself, what the new definition is and what it means. And finally, we're going to turn it over to Dick Stoll, who's going to speak briefly about what the judicial review provisions are with respect to the new rule. So then with respect to the Clean Water Act, the Clean Water Act is an act that basically prohibits discharges of any pollutant into navigable waters without a permit. And for purposes of our discussion today, what's really relevant is going to be what is defined as navigable waters, because it's those waters over which the federal government is going to have jurisdiction. And just to make sure we come full circle, and so we all have the same ideas in our head, I also just wanted to touch briefly on a pollutant. Again, we're not going to really focus on this today, but to the extent that that it's part of the definition of what's covered and when a permit's going to be required, it's just helpful to keep in mind that a permit is not just kind of the traditional idea of wastewater effluent or some kind of industrial discharge. It can also include natural type features, including rocks and sand, or even dredged soils which have been removed. And what types of activities are going to be permitted? The first category is the point source discharge category, and that's going to be, again, for the types of industrial wastewater effluent that may be, released through a pipe for an industrial process. And then the rest of these categories are really ones that are going to be the focus of our discussion today, or which are probably more impacted by the Waters of the U.S. rule. And those are the types of activities that include placing different types of things in water. So whether it be a type of fill, so you're filling a water, you want to place a structure in a water, or another type of permitted type of activity is going to be if you're removing something from water, so if you're dredging it, or if you're draining it. Also included in this is going to be a realignment of streams. And then also, again, is the potential for the replacement of native materials to be something that would be a permitted activity. So why do we care about federal jurisdiction? Because federal jurisdiction can have a lot of implications for a variety of folks. Manufacturers in particular have potential issues with respect to the effluent that may be going out through their industrial processes. But then, with respect to the Waters of the U.S. rule, several sectors that are going to be significantly impacted are developers, folks in agriculture, utilities, and then really any other sector, depending on a site-specific development issue. So to the extent that any type of business and any type of sector may have a property on which they would like to have an expansion, if there is a Water of the U.S. on that property, then there may be an impact associated with federal jurisdiction. Which agencies are involved in the Clean Water Act permitting process? So on the federal level, there are two agencies that are really responsible for this. With respect to the types of fill permits that generally occur with respect to wetlands or waters of the United States, the U.S. Army Corps of Engineers is really the agency that takes the lead with respect to that. They're the authority. They have the authority to issue the individual and general permits under which parties can place things in the waters of the United States. They're also in charge of conducting the various jurisdictional determinations to set out where wetland starts, and then also they share enforcement responsibilities with EPA in this role. EPA's responsibility under the Clean Water Act with respect to fill is really going to be more so in providing guidance and interpretations with respect to the substantive environmental criteria. They do share enforcement responsibility with the Corps, and they also have a veto authority under 404. Now, this veto authority is very sparingly used, and it was used only about 13 times from 1972 to 2011. And not to leave them out or neglect them, we do just want to comment that state agencies also play an important role in the Clean Water Act permitting process. Many state agencies are delegated responsibility under the Clean Water Act, but then they also have authority under state-only waters, because states can have different and more expansive definitions of what waters are covered in their state with respect to permitting requirements. States really aren't going to be our focus today, but there are some questions with respect to states' role going forward under the new Waters of the U.S. rule, so just wanted to make sure to include them here. So what are navigable waters? So under the Clean Water Act, the definition of a navigable water is a water of the United States, including the territorial seas. EPA and the Corps have promulgated a definition of that. This is the current existing definition. So in a moment, we're going to talk about the new rule that has been published and, has been proposed and has been published in final version, but has not been published in the Federal Register. And until then, the existing rule will remain in effect. And so basically, that's going to cover all waters that are used in interstate or foreign commerce, and then all waters that are in fact interstate, including wetlands. And then there's also a category for other types of waters, including wetlands, the use of or degradation or destruction of which could affect interstate commerce or those waters. And then, of course, there's also the territorial seas. So the line gets blurry with respect to this kind of other types of waters category, right? What about waters that don't qualify as a traditional navigable water or are not necessarily adjacent to a traditional navigable water or that don't cross the state line? There are a lot of waters, the majority of waters maybe in fact, that fall into some of these blurry categories. And so it's with respect to these that the jurisdictional question has been up in the air. And the result has been that there's been a tug of war between the courts and the agencies as to where jurisdiction lies. And so I'm going to go through some of the case law background to just kind of set the stage again for various definitions and how it's played out. So back in 1985, the Supreme Court weighed in on where jurisdiction lies in the United States versus Riverside Bayview Home. And in this case, this was an important case because it was the first case in which wetlands that were adjacent to a traditional navigable water were held to be covered. So the court also held that the wetland itself didn't actually have to be navigable, and that the coverage could include isolated wetlands. So if you were adjacent to, but you weren't necessarily touching the navigable water, then you could still fall within federal jurisdiction. So then in 1986, the Army Corps of Engineers developed what they called the migratory bird rule. And this was an interesting rule. It basically set forth that federal jurisdiction extended to any wetlands, including isolated wetlands, that were visited by migratory birds. The Corps rationalized here that there could be interstate travelers that would go between states that would hunt or bird watch. And so as a result, there was interstate activity associated with these types of birds, and so that was the rationale for this rule. In 2001, the Supreme Court weighed in again, and here they struck down the migratory bird rule and rolled back part of Bayview. What they said is, you have to have some sort of nexus to navigable waters. It's not enough to just have this speculative potential commerce clause link based on interstate birds. And that for federal jurisdiction to extend to these isolated, purely intrastate wetlands, there really needed to be some adjacency. And then again in 2006, there was continued to be uncertainty with respect to which waters were jurisdictional. And the Rapanos case is the one that has really been the source of a lot of uncertainty in the last decade, and is probably the main reason for the promulgation of this. So in the Rapanos case, the issue was, whether the Clean Water Act did cover wetlands that that didn't contain navigable waters and were not adjacent to waters that were navigable. And the issue comes in because there was a split here. There was 5 separate opinions. There was no majority, but there was a plurality and a concurrence. So the plurality decision in Rapanos was written by Scalia, and he was joined by Robert Thomas and Alito. And the focus of this of Scalia's opinion was that in order for waters to be within the definition of the Clean Water Act, they had to be relatively permanent. And with respect to that, he ended up developing a 2-part test. So first of all, you had to be able to show that the waters were relatively permanent, and also that there was some sort of continuous surface connection to the bodies of water, so that you couldn't have these isolated wetlands that were not somehow connected to these other bodies of water. But again, there was some uncertainty about where one water could end and where a wetland could be. So one thing that's important and that's relevant in the context of the new rule is that the relatively permanent standard or rule would not have included intermittent and ephemeral streams. Scalia did clarify that there were certain types of situations where, if there was an extreme situation like a drought, or if there was a seasonal river that did flow continuously during certain months, then those may be covered within the scope of jurisdiction, but that intermittent and ephemeral streams. So then moving on to the concurring opinion, Justice Kennedy wrote this opinion. And in his opinion, he really deferred heavily to Swank, and he focused on the concept of a significant. He took the position that the Corps had correctly interpreted that the Clean Water Act could apply to these impermanent streams. And he focused on the nexus and said that it exists if the wetlands significantly affect the chemical, physical, and biological integrity of other covered waters more readily understood as navigable. Now, the effect of this nexus requirement was that it was really going to need to be a case-by-case determination jurisdiction, and this is a more expansive interpretation of jurisdiction than the pluralities. Then also there was a dissent that was the remaining justices. They would have affirmed the decisions below that the waters should have been covered, and most importantly, they would have deferred to the core as to the definition of a wetland. So the rules that come out of Rapanos, there are really two rules. There's the Scalia plurality test and the Kennedy significant nexus. And there are very different standards that were articulated under each of them. So, first with respect to the Scalia test, that's going to be a relatively permanent body of water that's got some sort of continuous surface connection. But then Kennedy, his focus was on the significant nexus and proving that there is a significant nexus between the wetland and the navigable waters. The result of this is which approach controls. We're now almost a decade post-Rapanos, and the answer is still not entirely clear. And we can look to post-Rapanos case law to see that there has been ongoing splits between the circuits. And I'm not going to go through this chart in detail, but the point is just to demonstrate that there are circuits that have held that one test applies or that the other test applies, and there are a number of them that are applying both because it's just uncertain. So in the wake of all of this, the agencies have tried to clarify that with guidance. So EP and the Corps first issued a 2008 guidance, and under that they were very clear that the jurisdiction for federal authority could come under either standard in Rapanos, so either the Scalia relatively permanent standard or the Kennedy significant. And then in 2011, there continued to be uncertainty. If you want to look back at that chart, you could see that there continued to be a number of cases during the 2008 through 2011 timeframe. And so EP and the Corps were attempting to further clarify how to identify waters of the United States. Again, they were claiming that the jurisdiction could be under both Rapanos, both tests and Rapanos, and they were trying to be consistent with the case law history. But here in the 2011 guidance document, there was a statement that really jumped out at industry and got a lot of folks riled up. And that was a statement that EPA said that was previous guidance did not make full use of the authority provided by the Clean Water Act as interpreted by the court. So, again, although they were seeking to improve predictability and consistency, there was a lot of concern about this increase in jurisdiction that they were proposing. There was a lot of feedback that the agency got with respect to this 2011 guidance, and it focused on two things. The first was that basically the guidance was so broad it knew no bounds. Pretty much every water in the United States was covered, was a position that a number of folks were taking. And then the other criticism that came up was that by doing this in guidance, by clarifying the definition of waters of the United States in guidance, was that the agencies were really circumventing the proper regulatory process. And were doing so in a way that allowed them to expand their jurisdiction. They got a lot of criticism for that, and ultimately they ended up withdrawing that guidance. So the stage is set. Post-Rapanos, we have a lot of uncertainty about which standard applies. There was concern about the guidance because it was non-binding and not subject to notice and comment rulemaking. And in the interim, you have both the agencies and the regulated community having a really time and resource-intensive jurisdictional determination process, and it was a difficult thing for them. So then last year, in March of 2014, EPA and the Corps proposed a rule to change the definition of the waters of the United States. So the rule included the three traditional waters, which are, again, waters used for commerce, interstate waters, and then the territorial seas. But in addition, it also proposed 4 new categories. And I've listed them here, and I'll just mention them briefly. The first was that impoundments of traditional waters would be covered. Tributaries of traditional waters would be covered. All waters, including wetlands that were adjacent to other waters, identified in the other categories, would be covered. And then the 7th category of waters that would be covered were ones that were covered on a case-by-case basis, looking again at the significant nexus, trying to determine if there is a significant. So the proposed rule may have spawned more questions than answers. The response from industry and environmental groups was strong. Industry, again, thought that the expansion of federal jurisdiction was evident in this revision and was very concerned by that. On the flip side, a number of environmental groups supported the rulemaking, stating that it was what was necessary to protect waters of the United States. Another interesting element, and I think Louis is going to talk more about this, was the role of science. And I have science in quotes because there are times during the rule where the agencies actually refer to the science says. And so simultaneous with the proposed rule, the agencies had also put out a draft science report about the connectivity of streams and wetlands to downstream waters. And they really focused on that to look at, or to help them identify where this significant nexus exists. Another question that came up with respect to the proposed rule was, what was the role of states? There was an expansion of federal jurisdiction, which meant that more waters that were traditionally state waters would be covered by the federal jurisdiction and would therefore be subject to federal permitting. And so there were questions with respect to how this would affect states and their role overseeing their waters. And finally, just to comment on this, there was also a lot of talk in the time between the proposed rule last March and the final rule being published or issued about a possible legislative fix that would have limited the definition of waters of the United States and also would have ruled back some of the federal jurisdiction in favor of some additional state oversight. And with that, I am going to turn it over to Louis, and he's going to start by talking about the final rule.
Great. Thank you, Sarah, very much. So the pre-publication version of the final WOTUS definition was issued on May 27th, 2015. And again, just to clarify, that's a pre-publication version, so it's not yet been published in the Federal Register. We don't yet have any indication as to when that will be, but we expect it in the relatively near future. And then the rule will take effect 60 days after it is published in the Federal Register. So there'll be some dates to keep an eye on once that appears in the Federal Register. Another point to make that's kind of interesting is that, as Sarah mentioned, the proposed rule was issued on March 25th of 2014, so it's just a little over a year in which EPA and the Corps were able to finalize the rule, which is relatively fast, and maybe even some would say quite fast for the regulatory process, particularly considering that, as Sarah mentioned, the rule generated significant comment. I think EPA ultimately said they got over 1 million comments on the proposed rule. So there was just over a year to consider and address all those comments, make some revisions, and issue a final rule. There were some relatively significant changes from the proposed rule, and I'll talk about those in a little more detail as I get through the slides here. But just to highlight a few of them, Sarah had mentioned that there were 7 categories under the proposed rule, and that number has actually increased to 8 in the final rule, and the 8th category came out of a split between of the 7th category from the proposed rule into 2 new categories that I'll again give more detail as to later. There were also a lot of definitions that were in the proposed rule that were streamlined or even outright removed once the rule went final, and that was done really in the interest of adding more bright line boundaries and trying to take away some potential ambiguity that had been pointed out in the various comments that the agencies received. Ultimately, the changes that were made and even the definition of it by itself were done by the agencies to really minimize delays in costs, make protection of clean water more effective, and try and improve the predictability and consistency for both the regulators and regulated entities, because the process, according to I think most people would have agreed, could have used with some clarity and simplicity. So that was the goal of the agencies in the process here. And to that effect, one of kind of the overriding themes that will come through in the presentation here is that imposition of bright line boundaries was a high priority. There's going to be a lot more situations where case-by-case analyses that would have happened under prior regulations and guidance have been eliminated under the new rule. And so there's going to be some instances in particular where that's significant that I'll point out later. And then Sarah had also mentioned a possible legislative fix for this issue. And you can argue about, I suppose, whether you call it a fix, but there actually has already been legislation proposed to block the implementation of the new WOTUS rule. And that's the Regulatory Integrity Protection Act of 2015. It actually passed the House in early May before the pre-publication version was even issued, because obviously they saw it coming down the pike. And so it's now currently in the Senate, and no indication yet as to whether that will have any success, obviously, but it is out there and something that might be worth tracking, because it would impose significant barriers to the agencies implementing the new rule, would require them to reconsider a lot of it, and ultimately force them to get some more input from industry and other interested parties before coming out with a revised rule. So that's something, again, to keep an eye on. So now I'll spend some time walking through the relatively complicated categories of waters that are now covered. And again, I mentioned earlier that's 8 categories now that are considered waters of the United States under the new definition. The first 4, which are consistent with the proposed rule, are the traditional categories that Sarah mentioned earlier, and they're waters currently, previously, or potentially used in interstate commerce, interstate waters, including wetlands, territorial seas, and then impoundments of any of those waters, or anything else that qualifies. And no real controversy with these categories. And just a point to make is that the impoundments category is really out there to obviously prevent people from trying to defederalize waters by simply impounding it. If you qualify, you cannot get out of the definition by creating an impoundment of the water in question. So now we move into the ones that really have generated, I think, the most controversy related to the rule, these so-called non-traditional categories. And again, there's 4 of these categories, the first of which is quote-unquote tributaries of waters in those categories 1 through 3. And tributaries have long been covered under the waters of the United States definition, and so it's not really a new category in that sense, but what is new is the definition that the agencies have assigned to the word tributary. And you can see I've got it up there on the slide. It's a 2-part test for whether you qualify, the first part being you have to contribute flow to a water used in interstate commerce, an interstate water, or a territorial sea. And then the second element, which is really the significant one, is that you must possess the physical characteristics of a bed and banks and an ordinary high water mark. And so I'll talk a little bit more about that in a second, but I just wanted to point out a couple other interesting things from that definition. The first is that for that first element, contribution of flow, that can be either direct contribution, such that the tributary flows directly into the interstate commerce water, interstate water, or territorial sea, or it can be indirect, meaning it can go through another water. So if, for example, you have an impoundment that's located in the pathway of a tributary, and the tributary comes out the other side and ultimately makes its way to a traditional water, that the presence of that impoundment does not take you out of the definition of tributary. Another interesting element is that the tributary can be natural, man-altered, or man-made. So as long as you meet these 2 characteristics, it can even be a man-made feature that can ultimately qualify as a water of the United States. So I know that is often a question we get, and that is the case: man-altered, man-made, or natural. So to get back to that second element, the physical characteristics element, this, as I mentioned, is really the most significant addition, because it's going to bring in probably some waters that either were not previously covered, and certainly some waters that were at least previously subject to a significant nexus case-by-case analysis. And I've got another slide on this, but ultimately, the point to remember on this definition for tributaries is that any water meeting the definition of meeting these 2 characteristics is jurisdictional by rule, meaning you don't have a case-by-case analysis associated with it other than really to evaluate whether it meets these 2 criteria, which I think are a lot more straightforward than the significant nexus analysis. So these are now jurisdictional by rule, whereas before there would have potentially at least been subject to a case-by-case analysis. And the basis for that goes back to the science report that Sarah mentioned earlier, specifically that the agencies determined, based on that science report, that waters meeting this definition automatically or almost certainly will have a significant nexus. So essentially there's no need to go on a case-by-case basis and analyze whether such a nexus exists, because the science confirms that if you meet this definition, it does exist. So I wanted to just expand a little bit more on the comment about why the bed and banks and ordinary high water mark characteristics are so significant. This is one of the areas that I think a lot of people are focusing on as being an expansion of the Clean Water Act authority, specifically as it relates to intermittent and ephemeral streams. As Sarah I think mentioned earlier, the intermittent and ephemeral streams are those that can run only after precipitation events such as snow melt or heavy rain. And then obviously intermittent is pretty clear. They don't have relatively permanent or constant flow. And under the new definition of tributary, as long as they contribute flow to a traditional navigable water, and have a bed and banks and ordinary high water mark, they are covered. There's no need to evaluate whether a significant nexus exists. No other case-by-case analysis is required. And if you have those physical characteristics, you are now qualifying as a tributary. So again, this is an area that I think a lot of people view as an expansion of the authority, because these, at least under the plurality test and Rapanos, were potentially specifically excluded, and then under the Kennedy test were only covered if they had a significant nexus. And so I think there's going to be more areas that are reached under this definition of tributary. And I will note, too, that in a webinar that EPA held on this topic shortly after the pre-publication version was issued, they did try and clarify here that, those physical characteristics, the bed and banks and ordinary high water mark, are very critical. So it's not going to be, every desert runoff stream is going to now be a water of the United States. It really does have to have the bed and banks and ordinary high water mark. Time will tell essentially how much that impacts the expansion of authority, but I know that's obviously an issue that the agencies are well aware of and know that industry and others are viewing that as a potential expansion, and so are going to watch it pretty closely. So that's the tributaries category. That was, again, category 5 out of 8. And then category 6, again, identified as a non-traditional category, is waters that are adjacent to those listed in categories 1 through 5, and you can see what those are there on the slide. Adjacent waters were also covered under prior rules and guidance, and were also included in the proposed definition. And adjacent has long been defined as bordering contiguous, or neighboring waters. But there was some ambiguity as to what a bordering, contiguous, or neighboring water was. It led to a lot of the litigation that Sarah discussed earlier, and was really one of the hot button areas, I think, for people being concerned about Clean Water Act jurisdiction being overextended. And so the significant change that has come about through the rulemaking process here is a definition for the term neighboring. And this is another area where there was a significant change from the proposed rule to the final rule. The proposed rule really had looked to define neighboring on the basis of things like, quote-unquote, the riparian area and the floodplain, and those were defined terms under the proposed rule, and so there was an attempt to go about it that way. And I think a lot of the comments that were received after the proposed rule was issued really focused on this neighboring definition and how those terms, riparian area and floodplain, were potentially ambiguous, somewhat unclear, and really not a bright line test that maybe the agencies had hoped they were creating by defining the word neighboring. And so in the final rule, the agencies, I think, took great pains to make this more of a bright line test, as clear as they could. And so they've changed the definition, removed the words floodplain and riparian area, the definitions of those terms, and really focused instead on the two the two components here that I've got up on the slide. So first, a neighboring water is defined to include all waters where any portion is located within 100 feet of the ordinary high water mark of a otherwise covered water, categories 1 through 5. And then a second category is all waters where any portion is located both within the 100-year floodplain and within 1,500 feet of the ordinary high water mark. So obviously, given that they've got actual measurement boundaries here, 100 feet and 1,500 feet, that's obviously a pretty bright line test. A couple of points to keep in mind, though, is that it's any portion of the water falling within those boundaries. So that if you have, for example, a dog leg coming off of your pond or something like that dips anywhere within these boundaries, that whole pond, that whole water is going to be covered. So any portion makes it jurisdictional. And then a second point to keep in mind is that the 100-year floodplain is typically going to be based on FEMA maps or Natural Resources Conservation Service maps, which cover most of the country, and that was obviously the basis for why the agencies wanted to use it, is because there's a lot of coverage there. Ultimately, similar to the tributary definition, water satisfying this definition, no case-by-case analysis. The science report, based on the science report, the agencies concluded that a significant nexus definitely exists with respect to waters meeting these definitions, and so they are automatically covered. No need to do any kind of case-by-case significant nexus analysis. And I will say, too, the agencies mentioned in the preamble to the final rule that with this boundary of the 100-year floodplain and the 1,500 feet, the second one I have up there, the goal was really to give some clarity to those areas where the 100-year floodplain can be very, very wide based on the size of the water and the topography surrounding it. And that's why the 1,500 feet boundary is in there. And so that was again, the attempt, I think, in the agency's mind to limit the reach, but try and still get within that 100-year floodplain, which the science report indicated was critical in terms of affecting downstream waters. So that is the adjacent category. That's, again, category 6. And now we get into the ones that actually do involve the case-by-case analysis. So just to give a quick recap, the first 6 categories that I just talked about are all jurisdictional by rule. There's no significant nexus analysis involved. If you meet those definitions or fall within those categories, automatically covered. These next two, categories 7 and 8, you have to have a significant analysis. So that involves a similar case-by-case analysis that's been done in the past under existing regulations and guidance, but now there is a definition within the final rule that sheds a little more light on what that significant nexus means. And so that, again, that's another spot where the agencies are hoping there's a little more clarity, a little less ambiguity for both regulators and regulated entities. So obviously then one of the key definitions for these two categories, 7 and 8, is what is the definition of significant nexus? And I've put it up there on the screen for you, and it really functions, it really focuses on the effect on the downstream water that you're looking at, whether it's chemical, physical, or biological. There can be certain types of subsurface or shallow subsurface connections between the two. There can be surface connections. There can be just biological habitat issues between the waters. There's a lot of factors that go into it. So that analysis has now been codified in a definition under the final rule, and so there's, again, hopefully a little more clarity there. Something else that's an important factor in categories 7 and 8 is the middle of that definition talks about other similarly situated waters in the region. And so that essentially means when you're evaluating whether a significant nexus exists, you have to include an evaluation of other similarly situated waters. And you can see there what I've said is that what the definitions actually say, is that a water is similarly situated if it functions alike and is sufficiently close to function together in affecting downstream waters. And then you have to look within the region to find those similarly situated waters, which is based on the watershed for the water that you're looking at, the water that you're trying to affect either through dredging, filling, or otherwise. So those are some important things to keep in mind as part of the significant nexus analysis, because you're not just considering the water in question, you are considering that and other similarly situated waters in the region. So for Category 7, this is an interesting one because EPA has actually, based in significant part on the science report, identified several categories of waters that have effectively already been deemed to be similarly situated, meaning A, they're subject to a significant nexus analysis, and B, they all must be considered together within the region if there is a if you're trying to do the significant nexus analysis. So essentially, these are prairie potholes, Carolina and Delmarva Bays, western vernal pools, and there's a couple other categories listed within the rule. So just as an example, if you have a Delmarva Bay that you are going to impact with a project, a development project, you have to consider all Delmarva Bays in the region together when doing your significant nexus analysis. And so Category 7 is a bit of an odd duck in that way, but it's almost in some ways a subcategory of 8, what I'm going to talk about next. But it's just, the science report has led the agencies to conclude that these are automatically similarly situated. So then Category 8, which again, the analysis applies to Category 7, it's just the similarly situated difference. Category 8 is again another attempt by the agencies to do bright line test. They wanted more regulatory certainty, and so they really tried to impose some numeric boundaries, some measured boundaries that they could impose to make it clearer for folks. So Category 8 covers any waters that are located either within the 100-year floodplain of a category in waters 1 through 3, or within 4,000 feet of the high tide line or ordinary high water mark of water listed in categories 1 through 5. So again, it's a it's a two-part test. You have to satisfy Part A there within those numeric boundaries, and B, have a significant nexus to a water identified in categories 1 through 3. So you've got a locational limit in Part A, and then a significant nexus limit in Part B. And you can imagine there's going to be some overlap, most likely with adjacency and neighboring and some of the things I've talked about earlier. So that'll play out as the rule is put into place. But the important thing to remember is that, again, you have to have this significant nexus and satisfy this one of the two parts in A that I've got listed on the slide there. And I will point out, too, one of the interesting comments I think that the agency received throughout the rulemaking process was that environmental groups in particular did not want the boundaries that are now in A that I've got up on the screen here. They really wanted just to focus on the significant nexus because they viewed that as what was allowed under the Clean Water Act and what the agency should really be covering. And the agencies in the final rule did come out and say, we want to impose this boundary because we need the regulatory certainty. We recognize that there may very well be some waters that have a significant nexus but are outside of these boundaries that we are losing essentially by putting them in place. But, we're willing to give those up in the interest of regulatory certainty. So that might be an interesting element, and I'll be curious to see if any challenges to the rule focus on that element of it. And I will say, too, the agencies also based these boundaries on their long-standing experience in making jurisdictional determinations and found that the vast, vast majority of waters that have a significant nexus will fall within these boundaries. I've kind of talked about it throughout, and I know we're getting near the end here, so I won't focus too much on this, but the draft report that the proposed rule was based on that Sarah mentioned earlier was actually finalized in January of 2015 and was obviously relied upon heavily by the agencies, and I've kind of alluded to points that the science report effectively determines where significant nexus exists, and so they have used that as a basis for some of the definitions in the term and definitions in the final rule, and particularly significant nexus, tributary, adjacent, things like that. So they've relied on the science report in a lot of ways to eliminate the case-by-case analyses. So again, that'll be another interesting element to watch in challenges to see if the science report itself gets challenged or the way the agencies ultimately relied on it. So real quickly, because they're on the screen here, the agency has codified the exemptions that previously existed, as well as several exemptions that they had long been recognized in agency practice. And an interesting comment that I always like to point out is that they've actually added puddles to the rule, because I think a lot of people tend to use that as a rhetorical point of it. Every puddle is going to be covered, so the agencies have made sure to point out that puddles are not, in fact, covered. So talk a little bit now about kind of the impact of the rule and what it means for industry and others. The biggest comment, obviously, is that hopefully it will speed up the process for jurisdictional determinations. There's going to be less case-by-case, at least in theory, and more bright line boundaries, and so now that's ultimately going to make the process faster. The issue, though, ultimately is that also going to expand the number of waters that are subject to it, and maybe actually ultimately increase the regulatory burden just because there's more that is covered. Time will really tell, but an interesting point to make is that the agencies actually said in the preamble that they believe this narrows the scope of jurisdiction under the Clean Water Act, and so we'll see whether that plays out in practice, but that's going to be something that's interesting to follow. I think at this point it certainly appears that it will cover more, but time will tell. Some specific things to point out as well about what's going to be the effect of this. Ultimately, assuming you do have more waters that qualify as waters of the United States now, things that didn't previously qualify as waters of the U.S., there are some regulatory requirements tied to that definition that may now come into play for facilities that didn't previously come into play before. For example, SPCC plans, spill prevention, control, and countermeasure. If you have a water on your property or near your property even, that is now a newly covered water of the United States, the requirement to have an SPCC plan may trigger for your facility. Similarly, if you have a release to that water, you may now have federal reporting obligations, whereas before you had maybe only state obligations or none. And then similarly, again, wastewater and stormwater discharge permits. If you are going to impact that same newly covered water with your wastewater or stormwater discharge, you may now be required to get a Clean Water Act permit for that. On the development real estate side, you've also now obviously got more projects that are potentially subject to permitting requirements if you're going to fill a newly covered water of the United States. And then also there's now a new and maybe more interesting dynamic between state and federal regulatory authority. For example, I know there are states out there that the state has different regulatory authority over, quote, state-only waters, and what qualifies as state-only water is now a little more nebulous. So there's going to be some interesting interactions, I think, between states and the federal government about where the regulatory authority begins and ends. So with that, I think I'll turn it over to Ellie for our CLE polling question.
Thanks, Louie. So at this time, I'm going to read the CLE code for this program. So if you're in need of CLE credit today, please enter the 5-digit code into the poll question on the screen after I announce it and press the submit button. So the code is YLATS. Again, that's the letter Y, the letter L as in Larry, the letter A, the letter T as in Tom, and the letter S as in Sam. YLATS. Again, if you're seeking CLE credit for this session, please complete the polling question by entering the code that was just announced. The polling question will remain open briefly. For those seeking Kansas, New York, and New Jersey CLE credit, in addition to the polling question, you will need to complete the attorney affirmation form and return it immediately following the program. A copy of the form can be found in the resource list widget, and at this time, I will return the presentation over to Dick Stoll.
Okay, thanks, Ellie. And to provide a couple of segues between what Sarah and Louis just said and what I'm going to talk about. Louis mentioned that at least EPA's preamble says at one point that they think maybe they're narrowing the scope of the definition of waters in the United States. I don't think anybody really believes that, and I think their own press material when they came out with the final rule goes exactly the other way. They said over and over again they're providing more protection for drinking water to more Americans. So I don't think anybody thinks this narrows the scope. Also, Sarah and Louis both mentioned legislative action, Capitol Hill. I don't think anybody seriously thinks as long as Mr. Obama remains in the White House that there's likely to be any serious legislative action on this that would do any damage to the rule. But on the other hand, there will definitely and most definitely be judicial review. There's just I can't say anything more with 100% certainty than there will be judicial review. The other day somebody asked me, well, gee, now that Obama got 4 more people on the D.C. circuit of his own liking, doesn't this greatly enhance the chance of this being upheld in judicial review? Well, the answer is no, that's not really very relevant here because, as we're going to see, there's a good chance this won't go to the D.C. circuit. Everybody's used to major controversial EPA rules going to the D.C. circuit recently. When you think of the Clean Air Act and RCRA, you think of industry coming in and environmentalists coming in and states coming in on all various sides. Well, all those parties are going to be seeking judicial review, but it's not necessarily the D.C. circuit. In fact, when you go through this, it's probably unlikely that it'll end up in the D.C. circuit. At least that's my own projection. Well, what's going on here? Well, the general rule, if you take administrative law and judicial review and all that kind of stuff, and I'll go through this quickly, the general rule is you're entitled to judicial review of a final agency rule. Now let's talk about all agencies now. And the general presumption is that you get judicial review under the Administrative Procedure Act and under 28 U.S.C. 1331. There you see my bullet. It goes to district court, a federal district court. Now there's more than 100 district courts in the United, or there's almost 100 district courts in the United States. Unless, my third bullet there, an organic statute provides something else other than a federal district court. Well, for those of you who follow EPA, you know over the years that most EPA statutes do provide for direct court of appeals, and in fact several, in other words, you go straight to a court of appeals instead of the district court. And several of the statutes, like the Air Act, RCRA, Drinking Water, and so forth, provide D.C. Circuit exclusively. You notice I didn't mention the Clean Water Act there in that parenthetical. It is different. And as a recent law review article, really is a good article on this, says we've got an incredibly confusing and messy situation come up. So all those parties I'm telling you about now that always go to judicial review, you got industry, environmentalists, and states, and God knows who else. They're going to be filing in a lot of different places, in a lot of different courts. And what's the problem here? All right, the Clean Water Act does provide just that certain specific types of rules or actions will go to a court of appeals. And notice I said a court of appeals. I didn't say the D.C. Circuit. They'll go to a court of appeals. Look at that list. And then if you think about Louis' description of this final rule, frankly, it's hard to find how it fits into A, B, C, D, E, or F. There may be a couple of arguments that if you want to look broadly and take a real broad interpretation of what's going on here, other limitations, well, maybe you can say, well, this all ties into, because people are going to be regulated under 301, 302. They have to get permits. Maybe it's all a limitation in effect. But it doesn't really look like it. It doesn't look like it fits 509, which means if it doesn't, then judicial review will be brought in a federal district court, any of the almost 100 federal district courts. Here's the thing. And I've already said that this won't go to the D.C. Circuit automatically, and it might not go to any other federal court. There is some mixed case law. Look at my second bullet here. This has come up before. It's come up in like national permit regulations and so forth like this, where some circuits have reviewed EPA rules and basically said, we're going to interpret 509 very broadly. And they stretched the words of 509 to bring things in that you wouldn't normally think should be brought in to the Court of Appeals. So it's not, whereas other circuits have read 509 to say pretty much what it means. And if you don't literally fit one of those things, you're not going to be in a court of appeals to start with. You're going to be in a district court. And again, most people I've talked to, by the way, right now in industry really do think that it's going to go to a district court. But look at my last bullet there. It's not certain. So what do people usually do when it's not certain? They'll do both. I know right now that various parties are planning to file in various district courts, and they're also planning to file in various circuit courts. It's common to forum shop, as I say here, so people are going to try going to their favorite district courts. Like if you're against the rule, you might think about that judge down in Texas who has already enjoined Obama's immigration stuff. You might think of that as a good district court. Or if you're an environmental group, you might want to go to San Francisco. Who knows? So let's say what we're going to have is a whole bunch of district court filings and a whole bunch of court of appeals filings. At least there's this thing called the Judicial Panel on Multi-District Litigation that can sort that out. All those filings go there, and then at random, and I don't know how they do the random. I don't know whether it's like one of those bingo ball things or what, but at random, they will pick one court out of the many. Then the rule says is that parties can still move to transfer somewhere else for the convenience of the parties in the interest of justice, but it'll still end up in one court. Usually the court that gets it by random usually keeps it. But the problem is, in this situation, we still have probably one federal district court and one court of appeals, and it gets kind of messy. And think of it this way. If you're in a circuit like the D.C. Circuit, where courts have liberally construed the terms of 509, you might have a circuit court saying, well, we're going to go ahead and take this. Whereas let's say you're in a district court, which is part of a circuit which is not liberally construed, they might go ahead and say, we're going to take it. We may have judicial review proceeding in a court of appeals and a different district court at the very same time. Now, you may be wondering, does this all make a whole lot of difference in the end? We'll finally ultimately get to the Supreme Court? Probably. Yes, it does. EPA, I think, has taken positions in the past for a very liberal interpretation of what comes into 509. And one reason, of course, is it sort of speeds things up. You don't have to go through 2 levels of judicial review before you get to the Supreme Court if you're going there. But there's this other thing lurking in the weeds, and it's the preclusion provision of 509. And there's a similar provision in the AIR Act and RCRA and so forth. People are probably familiar with this. If this does go to a court of appeals under 509 and they say that they have jurisdiction and that holds, remember this old nasty little rule that's in the statute that says anything you could have litigated during that time, it's speak now, forever hold your peace. And then once the court rules on that issue, in future enforcement proceedings, that can't be an issue anymore. You can't defend based on that ground. Well, you can see why EPA loves that, okay? And you can see why, if you're in industry, you might not like that. You can see why, for instance, if this is a court of appeals thing and some ditch that Louis is talking about would fall clearly under the rule, and the D.C. Circuit, let's say, rules, yes, that EPA, you did right, that ditch is covered. Then 5 years later, and in some enforcement proceeding, and you want to say that ditch is not covered, too bad, you're out of time. Now, if on the other hand, if the district court is a proper forum, then that won't be the rule. This preclusion, this lurking in the weeds thing I'm talking about, doesn't apply if this is district court litigation. As the law review article said, this is a confusing mess. Everybody I've talked to said this is going to be a confusing mess. It's going to be fun to follow this in Inside EPA and B&A, Bloomberg, and all these other things. Once this rule hits the Federal Register, the judicial review mess is going to begin, and nobody can predict how it's going to end. And with that, Ellie, I'm done.
All right, so I think we'll answer any questions that we got, and I'm going to actually turn it over to Louis. I think he's going to handle the questions that we did receive.
Sure, and it looks like the one that we did get was related to the in the region analysis that I talked about in terms of evaluating similarly situated waters for purposes of the significant nexus test. And the question was related to any guidance on which watershed you have to look in order to evaluate similarly situated waters. And I can tell you in general there is some amount of guidance on that point in the preamble to the final rule, and then the preamble also references some discussion in the technical support document that accompanied the rule. But in general, the agencies are going to rely on available mapping tools and they topographic maps, elevation data, things like that. The way they've described it in the rule is the single point of entry watershed. So whatever the water you're looking at and all other waters that drain into the same watershed. And I know that the question looks like it was focused specifically on HEC watersheds, and I can tell you the agencies don't seem to have phrased it that way. They point back to the science report and essentially say it, quote, represents the scientifically appropriate sized area for conducting a case-specific significant nexus evaluation. So obviously that's a bit circular in terms of what they're looking at, but I think in general they're looking for what is a recognized watershed. And they also have interestingly said, for example, out in the West, where watersheds may be quite large, they do say there is some discretion to consider smaller areas if it doesn't make sense to look at such a large watershed. So the short answer is that yes, there is some guidance, but ultimately it's going to be somewhat case specific.
Okay. Oh, it looks like we might have gotten one other question, so I'll let you handle that.
Has groundwater always been excluded under the Clean Water Act? I think the answer to that is yes. I'll probably defer to Dick and Sarah a little bit, but I know it certainly is now, and my understanding is it always has been.
Yeah.
And an interesting point, and then I won't say any more, is that there were a lot of comments on the final rule because of the significant nexus analysis looks at shallow subsurface connections, and so there was some interesting back and forth, I think, on does that mean groundwater, and because that's excluded, is there authority? So that might be another interesting element to watch in the challenges that come in. And just one last question popped in: the proposed legislation to block the implementation. I'm trying to think of the website. We put a client alert out there that actually has a link to the bill tracker on it. So you can find that on the Foley website, and there's a link in there. But it's the Regulatory Integrity Protection Act of 2015. I imagine some Google searching around, you'll be able to find it relatively quickly.
Or we could send the guy who asked the question, the person who asked the question,
absolutely,
a link or something. Yeah.
Okay, great. So that concludes the question and answer portion, and we invite you to contact any of today's speakers if you have additional questions or would like more information on their particular topics. And that's going to wrap up our web conference today. So just as a reminder, today's program is being recorded and will be available on Foley's website in the next few days. And if you have any questions regarding CLE for this program, please contact Ellie Kemeter at ekemmeter@foley.com. At the conclusion of this program, a questionnaire will appear. Please take a few minutes to give us your feedback about the presentation today. It's important for us to know your thoughts and helps us shape our programs going forward. Thank you again for your participation.